Hello guys, take two. I guess the last video battery died and the file got corrupted. Fuck me, right? Here we are, foreclosure episode 2. We need to go over the definitions and get on a basis of communication. There's going to be some terms that are going to get stretched out and used in the different corners of objectively how it's used and perceived. And then we're also going to break down some of those and why it's been so confusing for some people, because it was made to, I'm not going to say intentionally made to confuse people, but definitely outdated, and it definitely needs to get fucking updated because it's still confusing people. So we're going to break everything down in simple terms. And again, we are not consultants, we're not lawyers, we're not attorneys, this is all just education so that our entertainment, because it is a fucking drama story, or whatever this is just able to be understood and not used. I'm not saying you can't use it. Again, take all of the tools and everything we are creating and having to go through, and from me, the first-hand preparator of in the middle of the fucking eye of the storm of all of it, to have to actually go use it yourself. But again, I will recommend our home equity invoice agreement because that shit's legit, and how this all ties to it and how it's been built compared to what historically has been built. So let's get into first some definitions. We'll throw in some updates on these two cases. Again, QR codes 620 and 511. Current foreclosure battles. But if you want to see the fucking front lines of fucking people getting flanked on foreclosures, go check these out. So here we go. Deed and title, two basic things. And if you want full depth of the different types of deeds and stuff, or for a full lesson scope of actual education, go find our pro training. It's free on our WealthTradie app, or I should be here somewhere on the YouTube channel. And while you're there, like, subscribe, share both the app and this. Plenty of content and plenty of tools in that app, the WealthTradie app, for real estate and actual foreclosure use. We'll get into how to use that. So first, deed. Deed is a physical document, but there is also physical forms of things and abstract forms of things. And that's where I get into the stretching of the words, why we need to take a foundation episode, hopefully just 30 minutes because this battery's going to die too, to get this out and through to you guys. And it takes fucking forever to upload these. Like, it took me 3 days to upload the last hour one. Like, I don't know why, but it did. Nonetheless, hopefully anyone that's watching these can volunteer themselves, just how I'm volunteering myself to give out all this education or experience and power through the WealthTradie apps or through this experience firsthand. But first, the deed. The deed is a physical thing. So if you think about the warranty deed or the quitclaim deeds, that is a type of deed that transfers ownership. And yeah, it's the physical fucking deed that has the most power. I'm talking old fucking lock and key safe. Where's that copy? If whoever has that copy, the holder of that document, the person in possession, that's the second thing we need to go over, is holder versus holder in due course. But first, deed. Warranty deed and quitclaim deed. That ownership deed, that type of deed, is very, very potent. And why is that physical deed more potent than the land record, what you'll find up on public record? Just because you record it does not mean bullshit. I mean, it means some shit, but still, you have plenty of authority levels, rank levels of power, of leverage, of how much title, authority, rights they have in something. So that's where we get into the second word. Title is what we'll get into. But first, the deed. The deed of trust, what is going to be in all of these foreclosures, or they'll reference to it as mostly the mortgage. And that mortgage word also getting included out there, and something we should define at the end of this too, because the mortgage, that word will get usually defined as the deed of trust side of things, the promissory note side of things, or a mix of all of that. It really just depends mainly kind of what state you're in, going through those statutes, how they define things. And that's why, again, this is specific just to this Foreclosure War podcast episode, tailored mainly to the two cases here, which are North Carolina state non-judicial cases. So that deed of trust is a personal property thing, and it also does not transfer ownership. The deed of trust is just a security assignment. It takes the promissory note of the mortgage of the loan situation. It takes that actual physical promissory note, which you probably won't find recorded anywhere. I wonder why. Compared to, well, if my title of my real property, the highest value of everything, has to be publicly recorded for this security reason, why isn't this the actual note getting recorded? Nonetheless, we're not going to dive into that. Definitions and terms. Deed and deed of trust. Warranty deed versus deed of trust. The warranty deed has different title attached to it than the deed of trust has different title attached to it. Title is just the rights and authority. Again, if you want a more picturesque thing that with images and stuff of trying to understand that concept, because even title agents get that wrong. If you're a title agent and you're watching this and you got it wrong, comment in the try to correct us in the comments. Trust me, there will be plenty of other title agents that will hopefully correct you on our behalf. But we're an open discussion too if you want to, again, say it's different. But in these, how I'm going to explain things, these are the definitions and terms. So this deed and deed of trust have two different titles, which is an abstract form of actual rights and authority. The warranty deed, quitclaim, even the warranty deed's higher than the quitclaim deed. But those are the two ownership transfer types of deeds that have the highest title authority on them. The deed of trust is just a promissory note. So if you try to transfer a deed of trust, which again, do not do this because this is the issues with these foreclosures. That's what is normally trying to get happen is they're trying to transfer a deed of trust, a security assignment document. Again, the promissory note and the deed of trust are two separate documents. When they try to assign that, they're trying to also say, oh, well, that follows, the promissory note follows that because what's on record, land record, is the deed of trust normally. So, hey, well, if the land record got transferred with it, then so did the note. Absolutely ass backwards. Go look up Carpenter versus Logan, 1873. Long standing. And again, that's a Colorado case. And these are two North Carolina cases, which a lawyer, again, is going to try to argue if, ands, or buts about whatever. Even though he knows it's wrong, that it's Colorado and it's not your state. Again, that is a long standing. If you actually go through the history of your state, as you, the lawyer, the bar licensed testy person, should go do your homework and your own research because it's not my job to educate you. You got the education and you're trying to use that education authority leverage against everyone. So you go do it. But if you look at the statute that's been legislative-wise and case law-wise placed out in every other state, it all follows that same story and case and situation, which basically goes on to bifurcation. When you transfer a deed of trust, it doesn't transfer the note. When you transfer the note, it does transfer the deed of trust. But if you're relying on that deed of trust as evidence document and proof that the note was transferred with it, you can't do it. It doesn't work that way. It only flows one way. And that's your basis of a lot of this, of just saying, hey, there's no standing in this shit. And again, you dive into a lot of Danny Hammond stuff, very, very heavy on just the strategy with, hey, everyone lacks standing in all these foreclosures. The principal thing of trying to rely on the deed of trust to foreclose on shit, that deed of trust is void. It's void, and even though you can keep recording this publicly on the land docs, doesn't matter how many documents you record. It is clouding people's title, which is an unclear path of how to statutorily just people over. Statutorily, people can fuck people over on foreclosures, but statutorily, there's no quick way to fuck people over of clouding your title. And it's very easy to cloud someone's title. Anyone can go do it. You just take a piece of paper, put the right information on it as an owner and dates and stuff, and go put it into the land record. You don't have to be the owner of the land record. You don't have to be anything. Again, they don't check ID. They don't check ID when you submit the judicial foreclosures either. They don't even check it at the fucking hearings either. Trust me, I've been to them. But nonetheless, and that's another issue on these foreclosures is the names. Like, You get on the sovereign citizen side of things and how you write your name of fine details, and that's more on the conspiracy side and stigmatized cultural things, and we won't get into that. We'll focus on kind of just correcting the system of black and white statute. This is what the statute is. The many of them, you have to connect them and understand, like, this is what valid means of a debt, and this is what a debt, the very corners and stretchability of the word debt can be actually used as. Debt not always being a negative thing for someone, it being a positive thing. If I give cash and debt to someone, trust me, there's plenty of financial fucking movability and things I can do that it's an asset for me. It's not a liability for me. And that's where it kind of breaks down. So that's what you have to paint very slowly, articulately to people without the evidence of behind the curtains for everything. To be able to subpoena records, what was it on your accounting? Was it an actual liability or was it an actual asset value to you? And that's where you get into the law of equity and the courts of equity, which is different abstract physical places while you're still in the same physical place inside that court, in the same room, in the same chair, in front of the same people. You can instantly change worlds and shift courtrooms through different procedures of asking the judge to sit in equity. And again, when you get in the non-judicial side, that's your main issue. It's like, hey, I can't fucking say all the predatory shit. I can't do all this and bitch, moan, and complain about all the things they do to trap you and all this stuff. And that's kind of the battle and foreclosure war that we have to actually go through. So you have those deeds, and there's more deeds than just those three types. There's plenty of them. So go find our pro course. It gives you free education and everything, and it gives you breakdown of all that stuff. For the title side, again, it's just giving you abstract rights. The title agents will ask, like I say, who's on title. And again, a deed of trust person is still on title if that deed of trust is valid. It's just not the full ownership title of the property. So those two things. Now we have holder versus holder in due course. And with this comes the breakdown between what the mortgage is. It has two components. It has the promissory note, which is the actual document that goes over the loan terms. Hey, here's the interest rate, the payment, blah, blah, blah. And then your deed of trust, which is the document that references that and attaches it to the actual real property so that they can have a separate document, the personal property, the paper, attached to the real property abstract-wise through the deed of trust, but physically move that personal property wherever and however they like without having to move the physical real property it's attached to. Now, how you move that between that personal property and the real property, since it's attached with that deed of trust, is very, very stingent, aka what we call scrutiny, aka what case law in North Carolina has called jealousy, and which clerks in North Carolina should be having neutrally, which if you look and just looking at the case, that jealousy and scrutiny is for the benefit of the debtor, for the person that's getting foreclosed on, the homeowner, compared to what it is culturally and emotionally kind of viewed as. And again, we're not going to go into any biasness besides the ones we have procedurally now documented and proven through habit, through just different lies at this point in perjury, especially if something gets signed. We'll wait and we'll keep some details out until it actually happens. Right now, for the foreclosures, again, here's the QR codes. They are set for 6/20s for February 23rd, right before the clerk's foreclosure order sale. And then March 2nd, again, right before that, on for 5/11's foreclosure sale, which again, we've had a bond hearing for 5/11, which I get into the documents of things, but that bond hearing still hasn't even been signed by the clerk, and it just shows, like, look, and I kind of called them out on all of it before it, and that's probably maybe why, again, just assumption, why they haven't signed it yet, because if they do, yeah, just let it be, and they maybe throw punches that a lot of people don't, that either just take, but I don't take them. I either just let them slide by me, or I fucking do a reverse card. You do a reverse card on them, like, it's going to bite you in the ass, because I'm not someone who just drops shit. You're going to throw a punch at me, and you're going to be the one eating it and holding that weight of it, holding that hand up because it missed me. It didn't land with me. Don't tread on me, motherfuckers. And I hope this instills that same kind of emotional fortitude and experience in you for you to do the same thing, to stand your ground as a homeowner, as a pro se, as investors helping people for the actual equity right thing, which is going to be probably the end of this to get into the equity side of things. But we're looking at the promissory note right now and the deed of trust. Promissory note and the deed of trust are part of the mortgage, and you don't want to split them up. A lot of people want to split them up on the financial side, so there's ease of movability and all this stuff. And that's why you get into the MERS, the Mortgage Electronic Registration System. Something try to add to that industry to try to speed things up while still legally, judicially being right. Now, and there's been an ongoing battle, war, theater of foreclosure about that MERS. And we're not going to go on to that side of the strategy of things because you don't need to. Again, if you go into like Danny Hammond, start with the basic stuff, standing. Show the standing, and if they don't have the standing, because it sounds like there's a bird in the house. Great. If they don't have the standing, the basic things, they can't even pursue in a judicial jurisdiction. So, hey, and that's where you get into the non-judicial side of the states where, all right, well, we're because it's the non-judicial side. Just how in the Marine Corps, when we have non-judicial punishments, it's the same thing in the civilian world, non-judicial proceedings instead of punishments. You can see the language there, but it operates the same. It gives you statutes, black and white letters to use that are outside of the normal judicial process, and that's where you get into quasi-judicial situations. And the word quasi, again, is just same, but not the same, which muddles stuff for clerks to like what can or can't I do, and why they lean on lawyers and not pro ses so heavily to tell them what they can or can't do, because obviously they're going to trust the licensed person compared to any pro se homeowner that's sitting in the defensive, debtor, bad look, you're just trying to get out of a debt situation. Yes and no. One, you go into the ethical questions that everyone should be asking themselves. Should all debts be paid? And again, anyone that plays if I gave money to anyone, I expect to always want to get paid. Yes. But also, you have to also see your own manipulation and your own corruption. If you're going to charge a higher interest rate for the risk of that, when are you ever going to eat that? Are you all just going to take that extra interest rate as benefit? And that's where, a lot of things end up on the equity side of courts of things. Like, an actual investor has to know, like, there is some kind of equivalent risk. So that's where they feel okay of saying, hey, no, your debt's gone. But again, we're not trying to take it to the equity side of the emotional side of trying to, take it that side. It's just statutes. Statutes already been regulated and put in place to have the scrutiny, the jealousy on these to stop this stuff. You just have to educate, unfortunately, the clerk and the judge to that stuff and put it on highlight for people. Unfortunately, the lawyers aren't going to do for you. The trustee, the deed of trust trustee is on, even though it's supposed to be a neutral third party, you can see in this case, 511, we've documented it's not. And they have actually submitted that perjury for that. They have lied to procedurally try to advance their judicial gain in the proceedings, ongoing proceedings. Which, again, that's where you'll get into legal maximums. But even if you shout out a legal maximum, they can still you're just a pro se. You don't know what to say. You're just talking about legal maximums. You're not licensed. You're not in our bar club, and you don't know. I know, and whatever I say to the judge or fib to the judge, I can fib to the judge, get it over with, and this will never get looked at again. Wrong, motherfucker. It will get looked at again and again and again until you're fucking corrected. And trust me, I will hold you accountable. One thing in the Marine Corps we know how to do is hold people accountable. From the smallest motherfucking thing of walking on the grass or wearing your cap the right way to the biggest, largest things that end up for life or death. And that's as simple as a broken drill bit piece missing, or a nut or bolt missing, something not cleaned properly on the field. You can get from the smallest things, and guess what? You're just digging yourself hole in a deeper and a deeper hole. And it's I actually got asked it the other day, like, why it's questionable why haven't they given up yet? Like, and even the clerks, you know, I mean, they haven't seen this kind of fight back or standing their ground properly ever. Even just starting in the standing your ground to fight back is very, very limited. And when they do, it's usually trying to argue stuff, which again, you have to play the game. You can't hold that stuff up until the game's opened up and you can. It's not a chess board. It's kind of like a Monopoly board, but again, this Monopoly board's not a circle. It fucking branches out based off stuff that keeps progressing and progressing. So let's get back to the definitions. We got 7 minutes left on the battery. So on the other side of things, the promissory notes is just the actual loan document. The deed of trust is what ties that to the property. That's what gives you the title to attachment to that property. But the deed of trust, again, that word deed in there is what everyone gets wrong. It's abstract. It's a security assignment. A security assignment that can go void and break that tie to the property, meaning that now you have an unsecured promissory note. Even though the whole document may say secured, well, guess what? The way it was operated and the way it was transacted, aka converted, which there's a statute that defines what that is, that a clerk won't even pull up because it's not in their little paragraph of their little statute to proceed on a non-judicial proceeding. So we take that and we switch that to, well, why are we calling it a deed of trust? Why don't we just call it a security assignment? Because that's what the fuck it is. It takes that promissory note and attaches it and makes sure it stays secured. So that when we understand that deed of trust is null and void, this is Carpenter versus Logan 1873 bifurcation, because they transfer that instead of the promissory note to try to hold shit. We're not going to get into what they're doing in the back end. But nonetheless, when they do that, it breaks it. It's null and void. Doesn't matter why or when it happens, it did. And it's not like you can revive that shit. Once it's unsecured, it's unsecured. It's detached. Now, as soon as it's detached, this is why it's important, because who knows who's doing what. The public land records are not the highest authority. The physical documents are the highest authority in the real side of things. It kind of reverse and flips on the holder and holder in due course. But on the deed side, it is 100% the physical document side. And that even goes for the personal property of that promissory note. You must have the original, a fucking photocopy. If you know there's a statute that says photocopies and stuff hold power, blah, blah, blah. How banking works and operates, photocopies don't matter. You can allow fraud and conspiracy to happen, whatever you want, whatever signature's on it, whatever notary's on it. I don't care. If you still don't got the wet signature ink, and that's where you get into debate. Well, is this wet signature ink or not? Well, that's the beauty of the blue ink, baby. Blue ink. Make sure you're signing in blue ink. Any legal document, because if it has to get photocopied and someone try to use it as a photocopy, very, very easy. Where's the blue ink? And they make it sometimes easy for you. They'll put colored photocopies of an image, like even their stamp, the exhibit stamp for whatever page they're submitting, as colored, but then the signature page on it, it's black. So it's like, look, this is not the original. And you can see the color difference between this page being a black signature and this one being a blue signature. You don't have the full document. You don't have the full physical asset. Just like if these windows and these doors or these cabinets, they just disappear or and got burnt down, the real property diminishes and the owner hurts. It's damages. The same thing happens with those promissory notes. Now you can say the MERS, fixes that and everything, and we're not going to get into that, but again, you'll have to go into statute of what's allowable and not allowable. We just got hit or told by Wisconsin police that they can't use video to say anything. Any video or evidence has to go get seen by a judge and say, yeah, that's what that is. That's that person trespassing, or that's what happened on your property. So if you have a ring camera or security cameras, they're all useless until you get in front of a judge. And even when you get in front of a judge, you can see where things are going. They try to say because of AI and one stuff. So now they're going to deal with it. They don't even have the system yet, besides the statute that says you must let fraud and conspiracy happen. And that's where you have two parties arguing, and that's when the judge has to, make a judgment on the argument rather than knowing what's actually right or wrong. But we're trying to get him more on the, hey, knowing what's right or wrong rather than the argument. Right now, it's heavily been based on the argument, and we need to get him so standardized and simplified so that it's not that. And that's kind of what we try to do with these cases of these judges trying to say, hey, we want your opinion published on this, and we want it on the full scope of every argument that we're putting out there so that all the different arguments and different statutes are put into one place. It may not be in one statute for clerks to know, but at least it's in one case so that common law case law can be used of any pro se, any lawyer, anyone can just say reference that. And even if it's North Carolina and you're trying to use it for a different state, you can easily get with a lawyer and find your state statutes that are similar in the actual definitions and black and white terms they use. Because yes, it does have minute differences, just how the deed of trust being a security assignment has a difference. It has a difference when how you use it too, and that's kind of why you want a lawyer that understands the difference between abstract and physical things. So getting on to the holder versus the holder due course, the holder is the person that actually has the physical document, the original physical document. Whether it's the warranty deed, the homeowner's got his physical warranty deed, and a lot of us, again, don't know where that is. You know what I mean? And there's plenty of properties I've had, I'm like, where the is my actual physical copy? And sometimes you might have an actual title insurance company that'll hold it for you. It really depends. There's many different situations. I've had some times where it's actual, I'll pick it up from the actual title agent, the actual original copies and stuff. A lot of people make the very, very misconception that once it's recorded on land, it's golden, it's good, it's sealed. No. Holder has power versus holder in due course. Just how when you get into the holder rights of a non-negotiable, negotiable instrument, the promissory note, or even the deed of trust, it's different compared to the holder in due course. The holder in due course is more the abstract side of the actual rights of who's the actual owner. Just how when I have this stick right here, I may be in this house and whatnot, and I'm the contractor, and I pick up this stick. Oh, this stick's mine. I hold it. I'm going to go use it, blah, blah, blah. But guess what? I'm just the framer, and guess what? This stick is actually the electrician's. The electrician paid for this. He's the holder in due course. Now, we're both in the same house, and we're both doing the same thing, and it's probably going to be used for the same shit. Nonetheless, you'll have trade wars, and this is why we have foreclosure wars. This same thing happens in this. Like, I may be a holder of something, but I may not be a holder in due course. And I brought this same example, to the attorney. This was the substitute trustee's attorney, which is supposed to be a neutral third party. Hey, you pick up a $20 bill on the ground. You may be able to utilize it, but you're still not the actual holder in due course to where that's your $20 bill. Now, what mortgage companies and the finance world does is they try to link and bridge that gap. And what they've done is they've done mortgage service agreements. So instead of a bank or lender holding all these notes and holding everything in their security deposit box and all this stuff, they'll give it to a mortgage service company and say, hey, you hold it. I don't have to deal with it, blah, blah, blah. And then there's other financial obligations that they, business service-wise try to agree on. Nonetheless, that's where you get into the MERS, the Mortgage Electronic Registration System. That is the mortgage servicer side of trying to make things easy for them. Hey, I don't want to keep all this paper. I don't want to keep the physical documents. Let's just electronically make everything. Big no. Again, there's power in the physical documents. There's power in the blue ink. That just doesn't go away just because we're getting more electronic and more advanced with electronics and AIs and stuff. Even though we can accept email signatures and stuff, or even that courts have to allow conspiracy and fraud to happen based off signatures and stuff. And that's why a lot of your arguments based off of the loan docs are just thrown out the window because you have no standing on that, because you need to take it down to the basics first and apply scrutiny and jealousy from the beginning. Start with people's names, which is a big issue on this. If you look how people write their names as the foreclosing parties, you need to, hey, is that one name, two names? How many enti is in this? And I'm not going to just trust the lawyer, what the lawyer says. Prove it to me, lawyer. Like, how are you actually proving that they're using their name the correct way? Or are you getting fooled over just like a pro se person can fool someone over, whether they're using their sovereign name or their signature name. There's a difference. There's a difference between your name in all caps or how you normally write it. There's a difference when you cursive write it compared to print it. The same thing goes with signatures and shit. Nonetheless, the holder, you may pick up the $20 bill and you're a holder of it, but the holder in due course is who actually owns that $20 bill. The bank and lender will give the mortgage servicer the documents and the holder. The issue is these servicers, whether it's the servicer's problem or the bank's problem, who the f knows. But the servicers try to use the MERS, and we're not going to get into that again, but they try to use that, which you shouldn't be able to use that anyways. Nonetheless, they try to say we're going to transfer it on the electronic system because it's easier to transfer shit. And if we ever try to get the physical documents, we can backtrack and find wherever the physical documents are, if they are actually keeping the physical documents. I don't think they are many of the times. Danny Hammond also doesn't. You can find him on this YouTube channel. While you're at it, like, subscribe, follow. Actually, hit the share button, send to him, and then go on his channel, find his channel, and then hit the share button, send it to our account. Just so, boost this and we can get more people on this and carrying the weight of this war, this foreclosures. So you don't have to actually carry all of it yourself. Trust me, you'll feel that the more people that are actually on this side, whether you know it or not, you'll feel that weight lifted to where it's not such an issue to go correct these clerks or the judge that you may have to correct tactfully in the correct way. So when we get to the holder in due course side of things, they have ultimate title and authority, just like the warranty and the quitclaim deed. They hold possession of everything. Now, the mortgage servicer may be the one that holds it, or even the deed of trust person. Technically, that should be the mortgage servicer. This is the deed of trust, the neutral third party person. And that's probably how it old school, took before we had mortgage servicers. But now we have mortgage servicers that more connected on the financial side of things rather than the trust deed side of things. So instead of it being with the deed of trust trustee, it's usually a mortgage servicer. A mortgage servicer tries to get with the deed of trust trustee, the neutral third party for this whole transaction, and saying, hey, blah, blah, this should happen. And this, so old school wise, a deed of trust person may or may not have been able to hold the actual original deed until the loan was paid off. That is totally ass backward. That does not happen in real estate. This is real law. It happens in personal property, your car title. It happens when you try to get a loan card title. That bank or lender will hold that title, the physical title document. And again, even states in that system, they have an electronic title system. But it's an electronic title system, not an electronic mortgage servicer system, which is a third-party business entity system and not regulated or governized at all. So they should be able to transfer shit and whatnot without having the title, right? I'm the owner of this car, you know what I mean? That's not how it works, you know what I mean? The bank owns that and he's giving you it. You're still the title owner. Once pay off the debt, they send you the title. On the real estate side, no matter what, your mortgage transaction, when you purchase property, you get two things. You get the mortgage deed of trust and then the actual warranty quitclaim deed. So that deed of trust person isn't actually, he may hold the actual paper copy of the deed of trust, but he doesn't hold the actual paper copy of the real deed of the property. So when he goes to try to foresell at a foreclosure auction on a deed of trust, he's not actually giving away the deed of the property. He has a new deed called a foreclosure sale deed that is supposed to have more title authority than a warranty or a quitclaim deed, and it never does. The warranty and the quitclaim deed, original ownership, still has more power than that foreclosure sale deed. If you have any questions about it, go look at what void ab need 2 is. Legal maximum for a case law, I think it's Strickton, I quoted in these for North Carolina, specifically shows, hey, judge says, hey, if a foreclosure sale happens based off of faulty shit that the clerk wasn't allowed or misdid, it's void ab need 2, meaning it was never actually done. It was void. Just like the deed of trust, they void. Even though it's on public record and on document, it's void. You just have to put everyone on notice and stop them and say, hey, if you actually take my property, I know what you've been pushing through. I know what everyone's been bitch moaning complaining about on public record, But if you bring the sheriff over and you try to evict me from my property on this void ab need-to that you've been notified, just how you try to notify me on the foreclosure sale, proper this, guess what? I'm going to have to push and try to get the sheriff to also say, hey, no, yeah, it's void ab need-to. That has the legal maximum. The clerk's foreclosure sale may be right or wrong, but hey, everyone's been put on void ab need-to. And that's where you get into, there's no precedent on this stuff, which is why you should probably, even if you're a lawyer or a title agent or anyone in real estate, go look at these. These are going to change real estate one way or another. If they say yes, or if they unfortunately say no. But guess what? Even if they say no, I get to take it to the next step higher and get the next authority higher level, power rank level, to say yes or no on. And then it just shows more history and more track of, hey, this is why this needs to stop and this needs to actually get corrected the way it should be easily corrected, because there's enough documentation now that it's not just about one case, or I have actually 2 cases at the same time, but it's not about 10 cases, it's not about 100 cases, it's not about a case study. It's about, hey, there's a fundamental structural problem that needs to get fixed. And then that fundamental problem is that pro ses or lawyers should be able to change and fix the common law and the actual law of the land through how the judicial system was built, of correcting itself, being able to use case law, use common law, being able to, even if those are wrong, still be corrected on the next branch, federal. So hopefully we'll never have to take that. Some people have happened to take it to that far. Hopefully we made it clearful enough and tactful enough and focused enough for everyone to use in kind of every corner and every stretch on this foreclosure front. The attorney, however, argued. He says, no, that's my $20 bill. I just laughed and I was like, that's totally wrong. And I couldn't do anything besides, look at the clerk and just look at their reaction to try to gauge who are they kind of siding with, and whatnot on what's legal. That's what's happening here. So you'll have mortgage servicers, or maybe it's the substitute trustee. Who knows what it is? Maybe it's just an attorney, a debt collector. Who knows? Someone's picking up saying, hey, I am claiming I am the holder of the note. And then they'll go publicly record a deed of trust saying such. Hey, I hold the note. This is my deed of trust saying blah, blah, blah. Yet, where's the holder in due course? And if you're going to actually foreclose on our property, guess what? We're going to have to know who the holder in due course is. On the documents, the original documents, if you're the actual holder, then you have to produce those documents to have standing, the original documents. You can't just use your deed of trust and say, hearsay, I'm going to claim that I own this original document, and then not be able to produce that original document. And this is where we get into what we really highlighted in these about it being very kind of unclear. It's 60 days for non-judicial that hearing must happen in 60 days. You only have 60 days from the original hearing date to actually proceed on that actual non-judicial foreclosure for the clerk. Yet, it's under a chapter that's about personal homes, primary homes. So it's very unclear and muddled. Well, what if it's a secondary home? What if it's under an LLC, blah, 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 all that stuff. It should still hold the same, you know what I mean? It's the same equitable kind of side or defense, but should be tailored and have precedent clearly somewhere in a judicial publication or in an actual case law or study of using it as standing for your argument to say yes or no and get judged on. That's what we put in here, saying, hey, 60 days should still be the maximum. If they're claiming that they're the holder in due course, even months after they've already recorded a deed of trust saying so, they should instantly be able to produce that document. And they can't. You look at how long the clerks allowed these to continue out, it's over 6 months. And it's like, what the fuck? They do not have the documents, and they keep, trying to continue or not show up to court, and then continue all these little fucking, games that you can play in the judicial court. They just kept playing it. And again, if you're a pro se trying to call out those little Marine Corps fuckeries that they keep trying to play in the game, and I can easily highlight them. If you don't think I can't highlight them, go look at our book, The Real Game Made Simple. We highlight a lot of the misconceptions or the manipulations or the corruptions inside the real estate industries. And you can see, we can highlight them in the judicial game too. But more than highlighting like everyone, you have to have a way to correct them. And we think we've had a way to correct them because we've not only given them and put them on notice of, hey, this is what it's right or wrong. We've actually drafted, documents saying, hey, this is what you can actually do now. It's up to you whether you're going to do it. I haven't documented any orders because, again, I don't think it should be pushed like that, just like the Marine Corps pushes it for, your highest enlisted to your CEO officer. Normally, even in most admin jobs, you'll have your admin sign everything up, draft everything up, and you'll just proofread it and sign it. You know what I mean? Not what I want with these. I want the full judges. He's putting his word, his every detail and competence into it. I don't want any arguing parties, lawyer, plaintiff-wise, defendant-wise, saying if, ands, or buts. I want the competence and the education from that judge or the judging authority, the clerk, being written down in their own words. I don't want anyone else's words. I want your words, because your words matter how you cast those spells. I don't want someone else writing a spell casting fucking order and then you just giving the authority and power on it, because that's not the title and position you're in. You're supposed to be the authority figure. You're the one judging everything, and you have to be able to be competent enough in your own words to be able to judge on that. Which, if you see the issue in that, and go look at 511s, you'll find it. Look at the last, close around these dates, last documents that are submitted, you'll find the exact reason why that should not be allowed and happen. Legislation-wise, I highly doubt that's going to actually be done. I don't even think there should be any arguments against that. I don't know. I haven't researched into it. But nonetheless, we've highlighted it, and we have a perfect example of why it shouldn't happen, aka perjury. And yet, as soon as there's a signature on it, we submitted the perjury docs. Nonetheless, the holder in due course and the holder. You have to be holding the document to have any kind of utilization of it. And what utilization you have to be the holder of due course. And again, the courts are going to allow them to use the $20 bill. They're going to allow them to use the loan docs or the deed of trust to go foreclose on stuff, even though they're not the holder in due course showing up and trying to push this shit. Because, hey, if you got a $20 bill, I'm a court, this is what I do, you give me the $20 bill, I transact it. Now, a lot of people's strategy and defenses is trying to say that's a counterfeit, that's not the right $20 bill. A lot of those strategies and defenses are, again, shot out of the court because, one, you're either in a non-judicial proceeding, or even if you're in a judicial proceeding, there's statute that allows conspiracy and fraud to play out. And then once it plays out and you have those damages documented, then you have to go submit it again in another case as the plaintiff instead of the defendant to go deal with that shit. What we're trying to do is just look at the standards of everything and show, like, okay, we're looking at what valid means. Is this a valid debt? Is this a valid note, aka original note? And if it is the original note, is it valid? Is it properly handled and properly put together? If you go into what the word affixed means and how you transfer a promissory note, the personal property side, there's ways that you transfer that. Like, even though you're not recording on land title, you have to transfer that properly. And it's not, give me a receipt and that stuff. No, it's just like a check. And checks are, again, just like cash, non-negotiable instruments. It's a financial instrument. That financial instrument, just because a bank's handling it or just because an attorney's handling it, doesn't mean it's getting handled properly. And especially if a mortgage servicer is handling it, they're probably definitely not handling it properly. And trust me, they're not. Don't take my word. Go take Danny Hammond's word for it. Go take American Association of Private Lending's word for it. Trust me, there's so many fraudulent, aka unsecuritized mortgage and loans that get voided out, get destroyed, get missed as papers and stuff that should not be getting pencil pushed through the judicial system, but it is. And that's this foreclosure war in this podcast, where we're trying to first see if everyone can understand, and if everyone can understand, then easily, it should be easily for someone to put it into legislation. But if not, we're trying to correct it at least through the individual actors and the titles that they operate in, through our pro se, showing you the walk, the path, as you're taking the punches in the worst spots, trust me. So the main thing is, those are our definitions. Hopefully that made sense. a warranty deed having the highest title of ownership, and a holder in due course having the highest title of rights to a promissory note and what's inside that promissory note. And even that promissory note may be changed in words to contract, to mortgage, to debt, and may be stretched in the words it's used. Same thing like the deed of trust. Again, the deed of trust is just a security assignment. Even some states and stuff will say mortgage as the deed of trust. So anytime they say mortgage, they mean the deed of trust. They don't mean the promissory note, which again, the promissory note matters because it matters who holds that stick, that original document, not what's just recorded somewhere of someone self-hearsaying, proclaiming such, especially when they don't have signature authority, just how the real property has to get transferred. If you look on your real property, who signs your warranty deed? Only the previous owner stating, hey, I'm transferring this to such and such. On your promissory note, who signs the promissory note? The maker, or who they say the maker is, but we all know who actually makes those, the mortgage or the person lending it. And that's where you get into what's really a fraud, you know what I mean? But hey, we can't, we got to have a mortgage industry. We got to let things get moving, you know what I mean? So even if you look at that, like when I signed that promissory note, it says I'm the maker of that promissory note, yet those aren't my words. Just how I highly don't think that lawyers or plaintiffs or defendants should be submitting orders for judges to sign, because again, it's not their words, and it's coming from a biased party's words. As much as you want to be a lawyer or a third party to the system, or a substitute trustee or neutral third party, it's all biased. You're on that plaintiff or you're on that defendant side. You're in two spots. You can't be in both. The court does not allow it. The only person in both is that sitting position, the judge or the one proceeding on the proceeding. And guess what? It needs to come out of their mouth and words so it stays unbiased. Again, that's not something we're going to change probably, but nonetheless, we can highlight it very prudent why it needs to throughout the mortgage and real estate industry and just throughout this actual specific case. So hopefully you understand that deed of trust, deed versus title situation, holder versus holder in due course situation. We haven't broken down really how it finites ties to the case. Again, these are all just definitions so we can get clarity for each other. If you want more on the deed title side, go into our pro course on our WealthTradie app, learn it, learn all the types of deeds and the different title authorities and leverage you have power-wise with those. If you're a title agent and this is just irking you because your standard of your industry says it uses the word one way or another, just like how, masons in the construction world, they irk with the word concrete and cement. There's a difference, and there's a level of knowledge and education when you know those differences and use them properly. If you think I'm using them wrong, correct me in the comments, please. If not, hit that like button, hit the share button, hit the notification bell button so that when these get actually heard by a judge, February 23rd, March 2nd, we'll be able to actually get another update out to you, and you can see what everyone's kind of been waiting on. Somewhat a competent, authoritative person's actual judgment saying yes or no to something. Because right now we have zero response to everything we submitted. And it's like, you're not going to just not say anything. I know the clerk and stuff can do it and whatever, but yeah, they're going to have to answer eventually. And if not, again, you're in a judicial system where a fictitious assumption has to play out. And the judge, if you actually tactfully allow them and force them to operate in their title, position, rank, structure properly, you can actually use the full force and the power behind the cast, the spells, the statues, and the different actual American fortitude that we have. Trust in the system. I'm not saying trust in the people, individuals acting in the system, but trust in the system. Take some faith in the system despite other attempts, other horror stories with this war, other battles that have been lost or not pursued again and again to make sure that it's corrected finally. Because again, you may have to take your case all the way up to federal depending on your system, your state, and who you take it in front of and do. Just the mood of the day of whoever's in that room with the battle with you. That's just how wars and battles go. It's the fog of war and nothing's certain. No matter how much black and white, no how much equipment, no how much tools I give you, no matter how much tools someone gives you. That's why, you have a whole lawyer industry that, just like the real estate industry for agents, have been heavily overused and heavily lenient on, when you can see for some things they're not needed. Hopefully this stuff is education and you understand enough so you don't need those either, and you can just go take it yourself too. A lot of this stuff you can probably just copy and paste and then figure out the different nuances for your state, your dialect, your county. Even go as far as, looking up who the clerk is that's going to be looking at shit. Who the clerk's assistant that you may get thrown to that may be signing shit and looking at shit. Who the actual judge is that you may or may not get thrown in front of. So yeah, it matters because, yeah, it's not just the words of the spell you say. It's how you wave the wand. It's how you tone it wise and stuff in front of that judge and in that courtroom. It's a mystical fucking world, and I understand the fear and the weights of the fog of war to step into those rooms and situations to be able to handle and deal with. A lot of people just don't show up, don't stand their ground. Hopefully this gives you enough power, gives you enough tools to change that. So please share it, like it, or subscribe it so that more people can get these tools thrown on in front of them. Otherwise, there's no store that they can come to. They can come to WealthTradie, but WealthTradie is only going to give everyone home equity invoice agreements, which if you get into home equity invoice agreements, we also know the power of utilizing wordplay. So home equity invoice agreement is just like how it sounds. It's taking your home equity and it's making it an invoice agreement. That's what a home equity invoice agreement is. So it gives a homeowner or a contractor the keys to unlock equity in properties without banks or lenders. It just takes a normal contractor's invoice or their payment term structures of, hey, I need this much down payment, I need this much monthly payment, but instead of just giving me cash, get it cash through a home equity invoice agreement, because that invoice, that contract is different title than your normal invoice or contract. And I can tell you 100% that home equity invoice agreement has the highest title out there if you're a contractor. I don't care what contract you have out there. I don't care what fancy bank you got with to figure out your flexible term payment options in-house, or if you're working with a bank or whatnot for them to take care of it for you. Is not as highest equity-wise, structure-wise, leadership-wise, accountability-wise, everything wise, the highest title out there, the highest powerful and leverage you'll ever have. Why? Because it's not just a home equity invoice agreement. It's a deed. It's not the warranty deed that transfers ownership again. It's a different type of title it transfers. It's a deed that gives you that passive income and gives you that liquidity and that movability of your home's equity without those third parties and banks. Because again, who signs those promissory notes? One signature on it. It's the person who signs a check and says, I'm giving this check to someone. That promissory note and that check you give to someone is signed and made by you, the homeowner. The same thing with the home equity invoice agreement. Same thing, you give that deed of trust to the bank or lender and they give you cash. Same thing, you give the home equity invoice agreement, aka deed of trust / joint venture in one document, not two documents. Now all it does is it simplifies things. Instead of having two documents as a promissory note and a deed of trust, to where that promissory note can move them on the market and have this whole concluded situation with foreclosure fraud in industry, we can't have this eventually going into, I don't know how long this has been going on, but no matter, I don't care if it's 100 years, just like the NAR is just finally getting hit. Like, I don't want 100 years down the road, this getting hit, home equity invoice agreements getting hit for any kind of foul players out there misusing it, whether they know they're misusing it or not. So we use everything on the equity side of things. It's one document, it's one physical thing. The deed portion of that abstractness of tying security-wise to the property is done on that document. And if the actual holder in due course, the person with the rights and everything on that, is all on that document, and it's a contract, just like how the contractor has normally, with two signatures on it, saying, hey, I'm going to perform this, and the homeowner, the lord of the land, also is going to perform this. This isn't this one signature thing where the homeowner is just saying, hey, I'm going to do this, this, this. It's a performance document, and there's I'm not going to get into that right now, but it gives you the strength and the bullshit we take out of it to make sure that you can't claim that this is a predatory document. You can't claim this is a predatory lending or situation with the home equity invoice agreement like you can with home equity agreements. When you have banks and lenders trying to set up kind of they're trying to transition out of interest and into equity, but they're putting their half-ass foot in there. Yeah, and then when they do put their full foot in there for full equity terms, they normally, structure it with you can only pull in, pull out so many times with the ARV, the value of the property. It's a lot of predatoriness in there. We take a lot of that stuff out. Again, this isn't for that. This is on the foreclosure side. The main thing is, though, since you're actually on that, it's sort of a joint venture / deed of trust. You're giving title of some kind of ownership to that home equity invoice agreement, either contractor or liaison, which could be an investor, realtor, broker, legal assistant, CPA, tax. Anyone can be a home equity invoice agreement liaison. How you use that liaison position is based off what that project or that home needs, that land needs. For Foreclosure Wars, obviously it needs someone to either just stand by you and hold some of that weight, carry some of that weight, or copy and paste these and go structure it for your case with the current state and laws and stuff. But nonetheless, you have equity in the property as the home equity invoice agreement liaison. At that point, you're an interested party on the property. And again, if you have another lien or another person trying to foreclose on the property, they can't restrict and take that property from you without infringing on your rights. And then that allows you to step in, whether the homeowner is going to step in, audit or not. And I'm not asking you to believe me. I'm just asking you to pay $1. $1. $1. That's all you need, and you get the home equity invoice agreement. It's for yours for life. You get $1 for the most highest title, powerful contract there is for a homeowner and a contractor and a real estate investor, or even lawyers that wants to deal with anything real estate. Trust me. If you don't believe me, we literally have a giant marketing campaign just built around it. If you can prove us wrong, or you can build a more powerful or more secured equity structure document like a home equity invoice agreement, prove it and sign up. Your dollar, it acts like a jackpot, like a Monopoly. Whoever can bust it gets that jackpot, that free parking, just like a Monopoly game. Otherwise, go download the WealthTradie app, get it right on your phone, read through it. It is a little lengthy. If you don't know how to read it, send it to your title agent, send it to your lawyer, send it to your broker, send it to anyone you trust in the real estate realm or even the legal realm, mainly the legal realm if you're going to use it for legal things, obviously. But if you're using it for everyday contractor stuff and whatnot, just take it to someone. Take it to your contractor. See if he'll say yes or no. That's all you really need. You don't need a legal person. We've already had our legal people look over all this. They've drafted it, so it's technically, it's obviously drafted by me, because it's just like your mortgage documents and your promissory now, the maker, you know what I mean? Except it's reversed in this situation. I have to say, oh, this bar license person drafted it, you know what I mean? When in reality it was, it's me, you know what I mean? Yeah, I gotta put in the structure. I gotta tell them what the this, you know what I mean? Obviously there's, teamwork and cooperation, oh, maybe I should get rewarded this way, maybe I should get, perceived this way. And this is why we will have, later on each individual state, just how the NAR did with selling agreements, equity invoice agreements, home equity invoice agreements, we're going to have the same thing per state. We're just new in this industry, in this game, in this system. I may not look as young as I should, but we got some mileage and years to still take down the road and take this international. So the faster we get through things, the better. So hopefully we can get these solved, and we want to take these federal. And once we get these solved, it's a lot of weight and a lot of workload off of us. We can tap into the foreclosure industry season market right now. I think that's going to explode on the home equity invoice agreement side. As much as I want it to change the construction and flipping industry, I think right now it's heavily needed on the foreclosure side, so that everyone has options to help each other and not being restricted by the current options and the current strategies and the current misguidance out there of bankruptcy or let me just settle with the banks. No, we're not settling anymore. We're not taking the hit settling through the bankruptcy. Again, even the word bankruptcy has a cultural stigma tied to it. If anyone truly knows what 4th of July is, that's what bankruptcy is. That's what we celebrate every Independence Day. We went bankrupt and we claimed bankruptcy. We claimed independency. The same thing is what bankruptcy is. So people have negative connotations about the word bankruptcy, but you celebrate it every year on July 4th. So it's like, that's the shit. Like, we're not even going to try to solve or fix, you know what I mean? Like, yeah, maybe you guys can help and blow up this YouTube channel, and then we may have some leverage or power and be able to change that. But otherwise, you know, let's take it from what I do know. I do know rank and structure. I do know Marine Corps, you know, how to deal with the fuckery games, how to deal with the green weenie, how to, you know, move around the Marine Corps fuck games. It's the same fuck games you see in these industries, the same fuck games you see in the judicial system that you have to tactfully correct. Because if you don't tactfully correct as a Marine, whoo, buddy, you're going to get fucked with. And then even when you do tactfully correct, you're going to get fucked with still. And trust me, I've been there. I've as a Lance Corporal, fucked with staff sergeants in titled positions of quality assurance positions of saying, hey, you're wrong, and this should happen. Obviously tactfully in the right way, but again, I get it blasted right in front of me, in front of everyone. Luckily, behold, you know, I had good leadership at that time during that. And lo and behold, he finally stepped in, you know what I mean? And he's like, all right, I see what's going on here. And, you know, we obviously had middle ground because obviously he's QA, staff sergeant, blah, 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 and I'm just Lance, blah, blah, blah. And, you know, it's more of a, let's just deal with each other instead of doing what's right or wrong on black and white. That can't happen in this system. In this judicial system, it has to go black and white. And if it doesn't go black and white, there's no middle ground of the judgment of, let's just make this agreement between these two parties and dismiss this to keep things going. No, I'm standing my ground, and don't tread on us anymore. Don't tread on us, homeowners, or the lords of the lands. We're not taking it anymore. And yet, yeah, banks and lenders, of course, fucking lords of the lands too. But they're so pulled into their banks and their work industry rather than their everyday home industry, the people and the communities that, the masses that they're dealing with and misconcluding, and who knows what they're doing. But it's incorrect that they're doing, and it's, whether it's right or wrong, it's not for me to say, but it's definitely utility-wise wrong and shouldn't be allowed. If they want to do what they've been doing utility-wise, they need to do it correctly. They need to hold the original documents properly. They need to transfer things properly. They need to have the same scrutiny that homeowners have with everything they do. Same scrutiny that DMV title agents have should be the same scrutiny that real title agents actually have, and real land record people should be title agents with the DMV scrutiny. And the same thing with the clerks, you know what I mean, and the judges. They should be name checking, ID checking. None of that shit happens. Again, I get it, workload and stuff, but that's what technology is here for. Especially if you want to claim undisputed ledger situation of deeds of trust or promissory notes, don't use a MERS. If you want to blockchain the MERS and then try to say some shit about, oh, well, that is unmutable, it was transferred at this time, this date, blah, blah, blah. Well, guess what? You got to make that shit public too. So even if you try to use it as privatized the blockchain, never mind. Foreclosure Wars, let's keep it on foreclosures. We're not here to correct the mortgage industry. We're just here to correct the foreclosure theater around battles between plaintiffs and defendants and the grounds that everything's played on. So please like, share, subscribe again. I know I've said it enough, but that's the only value that we kind of get from this. You know, I spent, 2 hours at least switching batteries and setting the cameras and stuff, and it's going to be another 2-4 hours. You know what I mean? If I'm taking that time out for free for everyone, all I'm asking is for a like. You know what I mean? A share obviously is more valuable to us, and even that notification button is higher title, higher value for us. And then if you can comment down to us, ask us any questions, and we can provide some more value to you if you're obviously adding some value back to us. Even a negative comment to us is still adding value to us, so let them rip. I don't care. We can take punches, trust us. But if you're going to tread on us, please don't, you can see what we'll do. We'll make things real public, real easily. You won't be able to troll with us. We're happy for conflict, but if you're just going to troll, fuck off. You know what I mean? More than fuck off, we're going to fuck with you just as much as you're fucking with everyone else. Nonetheless, I'm just ranting at this point. Hopefully I get another video up to you guys. We'll see. If not, we'll see you at the end of these 2 cases, February 23rd and March 2nd. Wish us the best luck. It helps all it can because, yeah, it either takes weight off or we know we got someone else standing out there backing us. We've got to take it further. We've got to continue the fight, continue to go up to the federal route and whatnot. Hopefully we don't have to. Hopefully we can not just write the spells down for everyone. Hopefully they've read that and that was enough. But if we got to go in and wave the wand the right way and say it the abracadabra fucking right tone to be able to cast the spells that shouldn't be needed to get cast. But hopefully we can cast these 2 and they're spellbounding long enough case law wise and judge publication wise to be used by everyone else and blanketed over everyone else to know that judges and clerks, there's scrutiny, there's jealousy, and if you're not going to uphold it, there's going to be tort claims, there's going to be 1983s, there's going to be actual repercussions because now it's outlined those repercussions to where you're not just fucking sitting in your title and not doing what your rank is actually supposed to be doing. So yeah, aloha.